Hello, everyone. My name is Katie Anderson, otherwise known as Caitlin Anderson. On behalf of Schoeneck King, I'm happy to be here with you today to discuss some important elements of compliance for nursing homes. So let's see. I'm going to try to get this PowerPoint to work. And here we go. All right. So about the team, one quick item to note: Raul Tabora was unable to join us today. However, I am very lucky to be joined by with Craig Anderson. Craig and I are not related, for all of you who are wondering. We're just two C. Andersons who work in Albany and are originally from the Southern Tier, but of no relation. And we are both excited, I think I can speak for the two of us, to say that we are to discuss ways that long-term care facilities and especially nursing homes can improve their compliance. We work and are a part of a very experienced team at Schoeneck King that is dedicated to working with long-term care facilities on regulatory and transactional issues. And as you know, just right up top, the format of today's presentation, just note, we're not going to take questions during the presentation of this webinar. But instead, what we're going to do, just because we tend to find this more useful for everyone and we can give better answers, is anyone with a question, email it directly to me. And I'll give you my email right now up top, and I'll give it to you at the very end, just in case you didn't write it down. My email is canderson at B as in Bond, S as in Schoeneck, and K as in King. .com, so Canderson at bsk.com. What we're going to do is we're going to take all of the questions that we've received, and after the presentation, we're going to provide a copy of the question and answer list so that everyone will have a copy of the questions. When we do that as well, we will provide you should receive by that point, or at that time, you will receive a copy of this presentation itself. All right, so enough of that. Let's look at the outline of today's presentation. Throughout this webinar, we wanted to provide you with some guidance on two important areas for nursing home compliance. The first area relates to federal regulations related to the requirements of participation for nursing homes. As you are all aware, these regulations should have been fully phased in over a period of 3 years, and as of November 28, 2019, should have been fully incorporated and implemented by each facility. The second area of today's webinar focuses on some general reminders and tips regarding the improving the effectiveness of a facility's compliance program. And just again, about the questions you receive, feel free to email me about them. So, before we go further into the substance of this program, let's just take a minute to briefly think about the different sources of regulations and protocols that nursing homes are asked to deal with. There are so many agencies, governmental or otherwise, that impact the business of running a nursing home. Today, we aren't going to be able to touch on the impact that each of these agencies can have, or how to ensure compliance with a particular enforcement agency. But hopefully, the information that we provide today can help you continue on the path of providing effective, quality, and compliant healthcare services. With that being said, let's just take a moment to remind everyone that the annual certification season is upon us. For those who have not done so already, please make sure that your facility is ready to complete these certifications based on the status of your facility by December 31st. For those of you who have done this process before, this screenshot from OMEG's website, where you file your certification, should look familiar. All right, let's turn to the compliance programs themselves. Nursing homes have for decades been the subject of strong regulations. However, there are a couple of historically significant time frames that we look back to in determining the goals and purposes behind structured approaches to implementation of compliance programs. In relatively recent years, 1998, there was a historical change from the federal perspective on compliance programs. Among other agencies, the Department of Justice commented that it wanted to encourage corporate citizenship and affirm the importance of strong compliance programs. Its emphasis on compliance plans represented a fundamentally different approach from traditional law enforcement. Rather than the FBI and Inspector General policing corporations, the idea was that corporations would police themselves. Rather than an adversarial relationship between law enforcement and the private sector, there would be a relationship of cooperation and mutual support. This was intended to benefit providers as well as successful compliance programs and to help them avoid potential civil and criminal liability. The Department of Justice explained that this approach was, with the theory that under a compliance program, providers become knowledgeable about where, when, and how fraud can occur. Additionally, about what laws and regulations require. They then are able to develop control, procedures, and reporting for vulnerable aspects of their operations to prevent common types of fraud. Additionally, developing and reporting audits that can detect fraud are a significant way to deal with problems when they are found. So looking at a time map of compliance, in approximately 2006, there was a resurgence and we're focusing on ensuring compliance in the healthcare world. Some of these significant events include, in 2006, you have the new crime of healthcare fraud. 2007, you have the implementation of the 2005 DRA and whistleblower protections and the false claim actions in New York. Additionally, in 2009, you have mandated Medicaid compliance plans. With that in mind, let's move to our first topic, requirement of participation. As most, if not all of you know, the Centers for Medicare and Medicaid Services, pursuant to regulation, require certain basic standards. The consolidated Medicare and Medicaid requirements for participation, the requirements generally is how we'll refer to them, for long-term care facilities were first published in the Federal Register in 1989. They have been revised and added to and updated since that time, but they have not been comprehensively updated since 1991. Essentially, these requirements of participation set a standard for quality of care that is required for facilities participating in Medicare and Medicaid programs. In talking about these standards, CMS recognizes the significant amount of time that goes into developing and implementing a compliance program. CMS has stated that it's not our intention to reduce staff time spent performing direct patient care. However, facilities must be able to demonstrate that care and services meet the requirements for participation. CMS also noted that since current requirements were developed, significant innovations in resident care and quality assessment practices have emerged. Additionally, the population of long-term care facilities have changed and have become more diverse and clinically complex. I think it's very important to pause for a moment and hone in on one specific goal that CMS had in mind. Speaking as quality assessments, compliance, and ethics, CMS stated, unfortunately, instances of significant lapses in care continue to occur in our facilities. Our requirements, including QAPI, compliance and ethics, and infection control, as well as requirements for policies and procedures, are intended to protect the health and safety of residents, prevent harm, and support quality of life for residents. Looking at the overview of the phases, this chart outlines some of the key timelines and types of changes that have been implemented pursuant to the 2016 rule and phases 1 through 3. As you are aware, many of the important changes were implemented in 2016 relating to resident care. 1 year later, CMS increased enforcement based on the updated F-tags. So just take a moment, look at that chart because this is very important to examine. there have been so many changes, and a lot of them are already in place, but we have reached phase 3. So turning specifically then to phase 3. This, again, it's been in place since the end of November. This chart shows final requirements and processes that must now be in place. So, for example, there have to be the administration of the governing body of quality programs. That has to be in place at this point. Additionally, the quality program development, implementation, and maintenance guidelines are also to be in place, as well as trauma-informed care. Among other things, phase 3 involves the further targeting of quality of care by focusing on items like the coordination, like trauma-informed care, and in order to ensure that the entire circle of care is part of a resident's care plan. Additionally, looking at some more things from phase 3, while infection controls had to be in place previously, phase 3 requires the appointment of an infection preventionist. Oof, tough words to say. On this note, it is important to realize that for many facilities, some of the phase 3 requirements are really minor changes. Under phase 2, you were required to put forward an infection control program. Now, at this point, phase 3, there is the requirement to have the infection preventionist. Many facilities already started doing this as a necessary step in implementing the infection control program. But there have been a few changes that may require a bit more effort for facilities. Perhaps, the most significant for purposes of our discussion today is the requirement to establish and implement a compliance and ethics program and to provide training on compliance. With that in mind, we are going to turn now to Craig's part of the presentation.
Thank you, Katie, and also thank you very much for your very generous introduction earlier. It is wonderful to be here, and it's wonderful also to be talking on one of my favorite topics, which is how nursing homes can better improve their compliance programs in order to, not only improve their business models, but most specifically how they can improve the resident care, or the care that's provided to residents. So I want to tell you a bit about my background with nursing homes before I launch into the compliance program aspect here. So prior to joining the Bond team, I was with the New York State Department of Health, where one of my main tasks was to review the enforcement actions against New York State's nursing homes. Because of my prior and current experience in working with nursing homes and other long-term care facilities, I feel like I'm relatively familiar with the difficult situations and other circumstances that are faced by administrators in trying to provide the best quality of care to residents, while also trying to operate the business aspects of the facility. If we could go back to the last slide for just a minute. Maybe we can't. Okay, here we go. Katie mentioned how some of these are really easy to implement. The infection preventionist, for most facilities, as she said, that was already in place. And at this point, naming an infection preventionist is relatively simple. But when it comes to developing the overall compliance programs, you're doing more than just developing one policy. Typically, you are actually trying to coordinate effective compliance programs. Okay, so this is a diagram we developed to try to show some of the difficulties and pressures that are faced as you design and implement a compliance program. So if we're looking at the top, we see OMEG, we see the Medicaid Fraud Control Unit or the Attorney General. We also see Department of Health and the Centers for Medicaid and Medicare Services. All of these have their own mandates and standards that need to be followed. And as we alluded to earlier, These government agencies require compliance with their respective rules and the regulations on issues that include billing, provision of care, direct care, ethics, reporting, confidentiality, and other items. And on top of these, facilities face issues dealing with data confidentiality, physical security, so security of the actual building itself where the care is provided. And then there's even threats of natural disaster, more within the last, probably since 2010, 2012, we've had an increase in Department of Health and CMS wanting to have facilities demonstrate and prepare for natural disasters. Any gaps in the ability of a facility to meet these requirements can damage the ability of the facility to operate efficiently and to provide the quality of care that it needs to for its residents. So creating a clear, effective compliance program is the only way to ensure that your facility is able to meet these challenges. Looking at the list of people who are in attendance today, it looks like most people are in the nursing home compliance world already. And I think of how vast the regulations are and the laws are impacting healthcare providers, and it's just such a daunting task to know everything and to know exactly where the pitfalls lie. So much of what long-term care providers do depends on diligence in knowing and following rules. This applies to the application of clinical care as well as the administrative requirements. The main causes of fraud and abuse fall into one of the categories that we see here on these slides. Not knowing the rules, I have found, is probably one of the bigger pitfalls. Now, admittedly, knowing all of the rules is almost impossible, given that the laws and guidance are always changing. So we have to make sure that we have ways of learning new information, whether it's through legal compliance teams, through state updates. That means being being diligent and making sure that you've received the latest Dear Administrator letters or other guidance that's been issued by the New York State Department of Health, and really being aware of what's going on in the industry. One example recently that impacts New York's nursing homes is a revision to the public health law, specifically section 2803C, which deals with resident rights. This was a relatively little observed change in the law that will now require nursing homes to provide to residents a statement indicating that the policy of the nursing home regarding the granting of physician privileges to patients. So that is something, honestly, we're not sure exactly how or when that will be enforced by the Department of Health, but it is out there and potentially something to be used as fodder or evidence of a survey deficiency. If we can go back, I'm going to go down just a couple other issues here. Ignoring the rules is a lesser problem. I think most of the people in the nursing home world understand that what they're doing is crucial. It's important. Not only are you helping someone through a difficult time in healthcare, you're typically doing that for someone who's more vulnerable than the rest of the population. So it's not a huge problem, but what I guess I see as far as ignoring the rules is not at the administrative level, but typically when involving the other staff members, some of which may be providing direct care, who feel that on a particular day at a given time with that particular resident, maybe they should deviate from the rules. That is awesome. So ignoring the rules, again, typically not an issue at the administrative level, but certainly a problem. And we're going to touch on try to address how we can better relate to staff the importance of compliance in just a little bit. I'll let you look at the rest. I suppose there's also failure to train and failure of the procedures themselves, which are something that is a little bit easier to correct in the administrative realm. You can move on to the next slide. Okay, so possible consequences for failure to implement a compliance program. So as I was discussing, the provision of healthcare to vulnerable residents is really a crucial and much needed service that is offered by nursing homes. And as a result of that, there are countless regulations as well as a number of penalties for non-compliance, some of which can be very severe. While most will likely be at the level of a corrective action or fine, and perhaps even an overpayment recovery, there are instances where the facility or its staff can face exclusion from participation in Medicaid or Medicare, or even criminal prosecution. Over the past few years, this has become an increasingly scary issue for the administrators and officers responsible for the facility itself. While I was with the Department of Health, I really tried to work with the department's surveyors and their attorneys, and that, I guess, would also extend to the nursing home facilities that I worked with there as well, where we tried to only enforce those deficiencies that were caused by some real act or omission. For instance, we made conscious efforts to waive enforcement of potential deficiencies when there was clear information supporting the fact that that deficiency was caused by the misconduct of an individual and not the facility. So for example, where an individual CNA or a nurse had done something that was in violation of the facility's policies, we typically, and the policies were also in line with the federal and state regulations, we would try to see if there was room to remove facility culpability. But this seems to be changing more and more as CMS and DOH, as a result, are more willing to fine for what is essentially a strict liability, which means that fact where a staff member does something wrong and having that be used as evidence of failure at the administrative level. This is further evidenced by the fact that DOH has, in the past 2 to 3 years, begun to enforce deficiency at lower levels and lower scope. So it's hard to keep up with the mindset of those at the Department of Health and CMS, but that is something to watch out for. So really trying to develop a compliance program that shows what steps you're taking is one way you can sort of draw a straighter, more, deeper line in the sand to show where facility action has been taken and where an individual has simply ignored those policies and procedures. And thinking about how to establish an effective compliance program, it helps to break the process down into a few parts. Focusing on the general structure of the plan, the assessment and analysis that's needed to develop the plans, to implement the plan, and then the actual implementation and training they need to accomplish. This table here is designed just as a quick overview of some of the more direct or immediate requirements of compliance programs that nursing homes are required to model their compliance programs after. The first phase of this being structure, this is where we would want to turn to say, what policies do we need? Oh, look, what structure do we need in an effective compliance program? Oh, look, we need policies, we need to designate employees, we need to train and educate, and so on and so forth. As you can see, New York's OMIG requirements for an effective compliance program list specifically 8 elements that must be met, including requirements for ensuring good faith participation by staff in systems, for protecting employees or others who may report allegations of violations. At the federal level, CMS, there's a list of 7 items very similar to OMIC's elements, which are designed to help providers identify key areas of compliance. One thing to be aware of, if you aren't already, is that CMS and OMIC have on occasion strongly emphasized the requirements that compliance programs be quote unquote effective. It's a broad word, and going back to our discussion just a moment ago on strict liability, again, where the operators or the administrators are held liable for mistakes that aren't really facility problems, but they're individual culpability issues. We have seen OMIG or CMS or Department of Health take the view that the fact that there was a deficiency or problem is, in and of itself, evidence that the compliance program is not effective. This isn't the most logical of an approach, but this is the attitude that many facilities encounter, and so having a strong compliance program can guard against this. Now, a few moments ago, I mentioned that one of the things that I see standing in the way of compliance is when a facility is unable to convey the importance of compliance to its staff members. When you're designing or updating your compliance programs, items 3 and 4 here under OMIG and CMS are, and actually I guess that would extend to 5 as well, are absolutely, these are really essential and must be viewed on a case-by-case basis depending on the culture and needs of your facility. What I mean by this is that each facility is, as you all know, unique. Although some of the requirements regarding training, reporting, and disciplining are set by state and federal laws, facilities may need to find, I hesitate to use the word creative, but you may need to find unique or creative approaches to implement these systems. Administration needs to be able to communicate with staff as to the importance of compliance. So in addition to administrators talking the talk, so to speak, staff also must see administration walking the walk. And I think, that generally it's not the problem that administrators aren't talking the talk and they're not walking the walk, but it needs to be something that is observed by the staff. So as part of this, strong and appropriate disciplinary actions must also be in place. When mistakes are when mistakes are observed, the staff members need to feel comfortable that reporting these observations will not subject them to retaliation. Administrators and administrative staff should also identify meaningful ways to encourage participation by all members and vendors in the compliance program itself. Moving on to the next phase here in developing an effective compliance program. Risk analysis and assessment. Now, when we use the word risk assessment, facilities really need to have a very big picture approach to identify all of the risks facing them, both internal and external factors. Speaking more on the internal factors, one thing that often goes overlooked is the fact that a continuous process of internal review is required. This can be achieved through a meaningful quality program as well as through facility assessments. Now, I want to focus a bit on the importance of conducting a facility assessment. This should be a key component of the facility's overall risk assessment. And although the terms don't seem too different, our team here at Bond uses the word risk analysis and risk assessment in the nursing home world to really cover the whole big picture compliance program perspective. The facility assessment, however, is a specific term of art that is required to be complied with under the federal regulations. nursing home regulations that were implemented in the 2016 rule. Specifically, nursing facilities must, according to CMS, conduct, document, and annually review a facility-wide assessment, which includes both the resident population and the resources that the facility needs to care for their residents. The purpose of this facility assessment is to determine what resources are necessary to care for residents competently during both day-to-day operations as well as emergency situations. CMS has online resources that facilities can use to complete this assessment and to make decisions about direct care staff needs, as well as the facility's capabilities to provide services to the residents in your facility. I think the CMS tool that's available is a good starting point. It's actually a great starting point since it's required, but really taking a look at your unique characteristics that make up your facility may be a way to improve that facility assessment. The assessment requires the facility to review staff competencies, equipment, and physical environment, as well as the cultural factors that may impact the facility and the residents. In addition to internal reviews, facilities should be up to date with industry-wide reviews, including the Medicaid updates, HOMEG, the OIG alerts as well, the Inspector General alerts. Speaking as to the Inspector General, it does have a specific compliance program guidance for nursing homes. The focus is on the prevention of erroneous billing and specifically discusses requirements related here. So you see there's survey criteria that are used in risk assessments. There are department by department reviews. It also speaks on billing issues, including resident MDS and RUGS scoring, treatment reporting, and screening for excluded individuals, and a host of other issues that you can see there. And it looks like I don't have a link up there, but I will provide the link to that along with the presentation for today. Okay, moving on to implementation, which is the third phase, but even though we've said that this is sort of a three-phase approach, it really is an ongoing thing here. So once the appropriate policies and procedures have been identified and reviewed, the final challenge is implementation. Government regulations, employees, market conditions, and resident health status, these issues are always in flux, however, which is why it's an ongoing process. You can never just simply have a compliance program that's static and fixed, because everything is always changing. Your program needs to be designed to incorporate change. This requires providers to be constantly aware of potential issues, and implementation also requires continual education and training. Implementation requires that the facility truly develop an environment where compliance is expected. Providers should be encouraging staff and employees to make internal reports when potential non-compliance is identified. Administration needs to make sure that compliance officers and compliance committees are functional and effective. Again, that big word, broad word, effective. And also that the organization's management is capable of making the final determinations required to further compliance. The facility must cooperate with all investigations and respond with the appropriate corrective action plans. One quick item to note in this regard is that communications between outside accounting or consulting firms are not protected by any privilege unless that firm has entered into a special agreement, often called a COVEL agreement, with a law firm, and the scope relates to traditionally protected attorney-client privileges. So as you're coordinating with your internal and external support teams for compliance, just be aware that not everything you need to be aware of what is and what is not confidential and what is potentially protected. In the end, the organization's management must be able to identify, correct, and of course prevent issues of non-compliance. This may require ongoing modification of policies and job descriptions, as well as continual in-services and other efforts to create a compliant culture. This last slide here is just basically a quick refocus of to draw your attention of where some of the reporting must occur here. So in ensuring full implementation, we need to remember that nursing homes in New York are required to report to several oversight agencies depending on the nature of the issue. It's not always the case where you can simply report to the Department of Health and be done with your compliance duties. Sometimes there's other places that need to be reported to as well. There are distinct reporting requirements depending on whether the issue was an overpayment or a billing issue, or whether the issue was based on allegations of violations against resident rights. With that, I guess I will turn back to you, Katie. Do you have anything to add or comment on?
No, I think that was very thorough, and I feel like I'm ready to comply with things.
That's good to hear, Katie. You know what? I do want to sort of make one more plug while I have everyone's attention, which is, while I was on the state side looking in at what nursing homes do, and sort of looking also at the legal industry that we're trying to work with the Department of Health and also the the nursing homes and healthcare providers who are providing the healthcare. I really enjoyed working with the bond team, which is why I'm so happy to be here. That's one of many reasons I'm so happy to be here, because in my experience, they had just such an in-depth knowledge of long-term care. So, being here with you and Raul, who's here in spirit, are really just. And we've also had other members and contributors in the past to this great program, and to some extent, we can provide insight on a one-off basis for general questions or even specific questions. And if we can ever do that, please contact us. Our information is up here. Be careful if you're writing to me.
Yep. Add the W for Craig.
But typically, we can turn around a list of questions to you in about a week or two. Please don't be afraid to ask any questions. Don't make them too specific. That would be my last bit of advice. But as far as details, excuse me. If you have specific questions about how to improve your compliance program, absolutely send those over to us. Okay, like I said, Katie, was there anything else?
No, I think, I just really hope that this webinar, serves as a reminder for the need to develop the effective compliance programs needed to conform to the regulatory standards and improve the quality of care for residents. Again, contact us with any questions. Those are our email addresses. Again, mine is the C. Andersons. Craig's is C.W. Anderson. Either way, if you address it to Katie and you send it to Craig, we'll figure it out. So it's no big deal. And we hope you all have a wonderful holiday season.
Thank you very much.
Thanks so much, everyone.